parties are bound by their agreement. Therefore, it cannot be had this body to bar the same parties from amending their petition. My Lord, my lady, this court has powers and jurisdiction to guard itself from abuse by any party seeking amendment of its pleadings. And therefore, the submissions by Mr. Milimo are speculating that parties indeed intend to abuse the process by making or introducing matters that would render the petitions totally new. My Lord, my lady, I've had Mr. Milimo submit that advocates who are not present they have no advantage of taking the directions that will be given. Every party that has been here has actually given an indication that they are holding grip of certain people. Therefore, no party will be prejudiced by any direction that will be given by this court. In conclusion, Mr. Milimo's opposition to the amendment of our petition is just filibustering of this matter. Because
what did you say? That one. It's just. What did you say?
It's filibustering. Filibustering.
What's the spelling? Filibustering?
Yes.
To?
Filibustering the matter.
What does that word mean? What is the meaning of that word?
To stall the process.
Yes.
That's an easier way of saying
Yes.
it. Yes.
Delaying something without necessarily breaking the rules, what filibustering is. My assistant is a definition of filibustering, but I had looked at it before deciding to use it. So it's an opposition for opposition's sake. Nobody intends to abuse the process of this book by amending. We'll add a paragraph or thereabout, and he knows what is like. The parties have submitted, depending on what will happen in the Senate. They given leave to amend their petition, so they are expected to do it. That does not amount to an abuse of the process. That's all.
Thank you. Do you have any parties online who want to comment on this matter?
My Lord, if I may just make one remark, and this one is for the benefit of Mr. Milimo. Last week on 11th of October, in Kerugoya, in petition number E014 of 2024, which is related to this subject, this issue arose before your brother, Justice Mwongo. And in a recent ruling, which you'll be getting a copy of today, Mr. Milimo vehemently opposed a similar application for amendment, and the judge made a ruling where he allowed these kinds of amendments. And what the judge said is that the mutating nature of this process
on our part, we thank you for your ruling this morning, and we thank you for allowing the fourth respondent to proceed with the constitutional process before it. On the applications made by counsel for the petitioners, we shall abide by the directions of the system.
Thank you. Do you have any parties, counsel online, who wish to comment on the application for leave to amend petitions? If there's none, I think you cannot amend a petition except by leave of court, and therefore the issue which we have raised, we need to consult on it and give an appropriate ruling. We'll therefore adjourn for 20 minutes.
And that is news just in. A three-judge bench of the High Court declines to stop the impeachment trial against Deputy President Rigathi Gachagua. The judges, including led by presiding judge Eric Ogola, Anthony Mrima and Frida Mugambi, have been deliberating the
of the Senate tomorrow would then necessitate putting an amendment to fully anticipate that outcome and have it brought before the court. That is all.
We don't want to close out anybody. Is there any person with further comments? Then we consult on these applications.
My Lord, for the respondent, I thought you are referring to the petitioners first.
All right.
For the response, my Lord, on the applications that have been made by my learned colleagues on leave to amend, my Lord, you shall note that there's been no disclosure on the would-be intended amendments that will be sought, my Lord, to be incorporated if leave were to be granted. My Lord, we want to avoid a situation where we will be faced with a totally new petition disguised, my Lord, as an amendment to the petitions before you. In our humble view, my Lord, there's a very good reason to request that if there's any party, my Lord, who would wish to file an amended pleading, my Lord, that they seek that leave formally by way of an application, so that then, my Lord, the respondents will be given an opportunity to appreciate the nature of the would-be amendments and respond accordingly, my Lord. To seek leave, my Lord, in the nature that have been done, my Lord, an open blanket leave would, my Lord, be totally unfair to the respondent, as we do not know, my Lord, how that leave would be utilized. My Lord, we are therefore vehemently opposed to that application of leave to blanketly amend the petition. My Lord, there are rules that govern amendment of pleadings, and before you grant that leave, my Lord, you must be certified that that threshold has been met. None has been demonstrated, my Lord, by the blanket requests that have been made by our learned colleagues. My Lord, on the other request that we mentioned this night on Friday, my Lord, I will refer you to the ruling that you delivered this morning, where you've been expressed, my Lord, that this court would provide a remedy at whatever time is moved appropriately. You've also, my Lord, stated that it will not be right for a party to anticipate or engage this court in speculation. To therefore, my Lord, seek a mention on Friday, my Lord, based on the same reasons of speculation and anticipation, my Lord, would be contemptuous, my Lord, of the ruling that you have delivered. My Lord, we had indicated before you yesterday that we have about 23 matters related to the consolidated petitions before. My Lord, we've hardly had time to, my Lord, engage in those matters. The petitioners before you, my Lord, have had their share of the judicial time.
Mr. Mlimo, if we were to know what we are going to say, we are going to limit the time, because the applicants have not used the amount of time you have used in response.
Thank you, I'll wind up. I think, my Lord, therefore, I would request that you do not give them, my Lord, that request for Friday. That, my Lord, you allow this matter then to take its normal cue. And that, my Lord, we will be available to come back before you any other date, my Lord, next week, for a mention. I should have not, my Lord, all our other colleagues are before the Senate. They are not here, my Lord. We do not have their diaries. We request, my Lord, that you decline that request to appear before you Friday. I thank you.
Thank you.
Lord, from the leadership, give just 1 minute to respond to those issues. As regards the issue of amendment to the petition, Lord, at the time a petitioner is approaching the court for a remedy, we don't disclose essentially what the nature of the petition is. A party is free to file a case before the court and raise issues where the respondents then have a chance to respond. So that in case an amendment petition, your Lordship, is filed, the respondents will not be prejudiced in any way because they will have an opportunity